If this is your first time you're watching or reading materials regarding doing business in Russia, we hope you will find our information and the services we are providing a useful companion and supportive guide throughout the whole journey, or at least initial steps of the journey in the Russian business terrain. The past few years have seriously changed the business environment in Russia, making the Russian market more popular and comprehensible. The legislative and regulatory efforts are meant to improve stability and predictability, making the investment climate and the business environment more attractive for foreign businesses that harbor aspirations to enter the Russian market. So when entering the Russian market, a foreign business should in the first instance choose the business presence. And they are as follows: a limited liability company, a joint stock company, representative offices or branch offices of foreign companies, as well as limited and unlimited partnerships, and other forms which are not commonly used by foreign companies. All the forms of business presence that I mentioned are described in the Civil Code of the Russian Federation, as well as in other relevant federal laws, since Russia practices the Continental or civil law system, as opposed to the common law in the countries of the British Commonwealth, in the USA and some other countries. The rights and obligations within each form of a legal entity are usually strictly prescribed by the Russian legislation, and this is why we highly recommend to pay attention to the form of a business presence during your initial steps when entering the Russian market. Besides a comprehensive approach to the choice of a form of a business presence, we would recommend it to a foreign company to pay extra attention to the twists and turns, or in other words, peculiarities of the Russian employment legislation, which is historically very conservative and pro-employee. An employment relationship is defined in the Russian labor code as the personal performance of an employment function by an individual in return for remuneration. And a simple example of possible difficulty: for example, a civil law service agreement includes aspects that can be construed as an employment relationship, and the mandatory provisions of Russian employment law will apply in this case. Needless to mention that any foreign national have the right to be employed in the territory of the Russian Federation only on the basis of a respective work permit, even if he or she is the owner of a business or a member of a top management.